Vince Warren, our guest, Executive Director of the Center for Constitutional Rights. The importance of this argument, Vince? It's critically important because that piece of the argument shows precisely why habeas corpus, and that is a proceeding in which you have a lawyer, where you have counsel, where you can present evidence on your own behalf, where you learn the details of the evidence against you. That is why what we're fighting for is so critically important, because besides being able to determine issues of being in the wrong place at the wrong time, when the government says that there is a terrorist that you're known to have associated with, and who's dead now, and you were in a proceeding where you don't have that information and you can't follow up on it, you don't have the ability to say, oh my goodness, this person is not dead and he's not a terrorist, and that person can be the basis for your release. When the government says, accuses you of something that is simply not true, the basic tenet of our justice system is for you to have an opportunity to challenge that, and that's what's missing from the kangaroo court proceedings that the Bush administration has put into effect. Solicitor General Paul Clement argued the Bush administration's case. In an exchange with Justice Stephen Breyer, Clement was challenged on whether current procedures give prisoners any room to challenge their imprisonment.
That you are from Bosnia and you are held for 6 years in Guantanamo, and the charge is that you helped al-Qaeda, and you've had your hearing before the CSRT, and now you go to the D.C. Circuit, and here's what you say. The CSRT is all wrong, their procedures are terrible, but Judge, for purposes of argument, I concede their procedures are wonderful, and I also conclude it reached a perfectly good result. Okay? So you concede it for argument's sake. But what you want to say is, Judge, I don't care how good those procedures are. I'm from Bosnia. I've been here 6 years. The Constitution of the United States does not give anyone the right to hold me 6 years in Guantanamo without either charging me or releasing me, in the absence of some special procedure in Congress for preventive detention. That's the argument I want to make. I don't see anything in this CSRT provision that permits me to make that argument. So I'm asking you, where can you make that argument?
I'm not sure that he can make that argument,
exactly.
Justice Breyer. I'm not sure he can
make that argument. How does this become an equivalent to habeas, since that happens to be the argument that a large number of these 305 people would like to make?
Solicitor General Paul Clement and Justice Stephen Breyer. Vince Warren, this line of argument. This was a very interesting line of argument. What Justice Breyer was doing was setting up a hypothetical, and this was around the CSRT process. And just to remind folks, the CSRT process is one in which the detainee does not have a lawyer, cannot present evidence on his own, cannot see the evidence against him, the classified evidence, which is troubling enough. But what Justice Breyer is saying, let's assume that that doesn't matter, and that you are in the position of one of the petitioners in this case, someone from Bosnia who was not picked up on the battlefield, and you simply want to make the constitutional argument that under the U.S. Constitution, the president cannot detain me for 6 years without giving me a trial or releasing me. And Justice Breyer asked Mr. Clement, can a petitioner, and namely one of the petitioners in this case, can they make that basic argument? And Mr. Clement had to say no, because the CSRT and the Detainee Treatment Act process does not have a provision to allow for release as far as the statute goes. And that's a tremendous problem. And what that means is, under the proceedings, all a detainee can do is determine whether all a judge can do is determine whether the proceedings went according to the military's plan, but you cannot assert broad constitutional questions about whether the president had the right to detain you in the first place. I'm looking now at the Washington Post, since we're in Washington, D.C., and it says Chief Justice John Roberts and Justices Antonin Scalia and Samuel Alito were the most skeptical of Waxman's arguments. Scalia asked Waxman if he could name one single case in the nation's history or in 500 years of English law that would extend the writ to foreigners detained outside the country. Waxman responded that the answer was a resounding yes, but nothing he produced satisfied Scalia, who repeatedly returned to the question. Vince Warren. That's exactly what happened. It was
it was interesting. Seth Waxman listed off, and I didn't count them, but it was very close to 15 or 20 cases in multiple jurisdictions in different countries in which courts going back close to 400 years had cited the precise principle that was at issue in the case, and Justice Scalia was not at all satisfied. And I think Mr. Waxman tried 3 or 4 times to satisfy him, but it simply wasn't happening. But you know, it's a red herring in a large sense, because if the justices that were not particularly moved were justices that were in the minority of the Rasool decision in 2004, and the majority in that decision felt quite clearly that the rights that issue really did extend to the people in Guantanamo. And in fact, a number of justices, after the back and forth with Justice Scalia, said, well, it seems to me that we've reached that question before and we need to move past it.
Anthony Kennedy is considered a swing vote here. He was focusing on what are practical solutions.
Yes, Justice Kennedy is considered someone whose vote is key. Of course, as we know, we need to win this, well, anybody needs to win the case by a majority, which would be a minimum of 5 people. He was focusing on practical considerations, as far as I could tell in the argument. You know, the question, I think, with Justice Kennedy is whether he's comfortable moving forward, making a broad pronouncement about the right of habeas corpus extending to the detainees, number 1. Number 2, determining that the CSRT process and the DTA review process is not a substitute for a suspended habeas corpus. And then the question that remains is, what is the Supreme Court going to do? Are they going to return it to the lower courts with specific instructions how to move forward, which would be optimal, because the right of habeas corpus is supposed to be a speedy right, and it's been 6 years. Or is the court going to return it to the district court, the lower courts, to figure out what to do, which would take substantially longer than if the Supreme Court took the bull by the horns.
Finally, Vince Warren, the Supreme Court has considered this twice before. What's going to make 3 any different?
Well, the first case was an issue that was closer to this. The second case focused on military tribunals and not the DTA process, although that there were important decisions in the second case. That's the Hamdan case that, and most notably, the Center for Constitutional Rights position that the Geneva Conventions did apply to the detainees at Guantanamo, and the court did rule that way. This case is going to be potentially different, in large part because of the plaintiffs themselves. And there are 37 plaintiffs, most of whom were not found on the battlefield. There were a number of plaintiffs that were from Afghanistan that were sold to the U.S. through bounties. There are 6 detainees that were from Bosnia that actually had no connection to the battlefield at all and were turned over to the U.S. by Bosnian governments. And so the question here is not a question of, is the government trying to release the worst of the worst? It's for people who have had no connection to the war on terror and who are asserting that they're factually innocent. Do they have an opportunity to do that under these procedures? And I think the answer is clearly no. And I think that might lead the court to push forward with a very broad pronouncement. And hopefully Congress and the President won't continue to sidestep the Supreme Court ruling.
Vince Warren, I want to thank you very much for joining us. Vince Warren is Executive Director of the Center for Constitutional Rights.